Hello and welcome again to Immigration News and Views. My name is David Nachman and I'm one of the managing attorneys at the NPZ Law Group. That's Nachman Fawani Zimochek Law Group. We have offices located in northern New Jersey, in central New Jersey now with a new office that we opened in Nestanek Station near Branchburg. And we also have an office in Midtown Manhattan and a small outpost in Indiana. So I'm coming to you today to describe some of the recent changes that have been made to the Foreign Affairs Manual with regard to what's called the 30-60 day rule, which I believe we've talked about in the past. The 30-60 day rule has to do with a concept called preconceived intent. And what essentially the rule said was that if an individual is coming to the United States and doing something that was, let's say, contrary to the original intention that they had manifested at the U.S. consulate abroad, that the 30-60 day rule could be sort of garnered by the government to say that there was some type of a misrepresentation that was being made about the intention for the individual to enter the United States. So for example, if an individual entered the United States and then within 30 or 60 days what they did was they changed their status, filed for a change of status to a student if they entered as, let's say, a visitor, when the intention that they had manifested when they did their visa processing was to be a visitor, and then they enter the United States and change their status to a student, that can be deemed to be a misrepresentation. So the recent guidance, which came out on September 1st of 2017, talks about a change to this rule in the Foreign Affairs Manual. And I think it's important to point out to our viewers that this is a rule which is in the Foreign Affairs Manual, which is the Foreign Affairs Manual is a document that governs processing of visas abroad and does not necessarily deal with visas in the United States. However, of course, the officers could turn to this change in policy or change in rules, and they could use that, here in the United States, the U.S. Department of Homeland Security could use this rule. So essentially now what they've done is they've moved this period of time from 30-60 days out to 90 days. And essentially what they're saying is that if there's an inconsistency that is done with regard to an individual's entry and the original representation that was made at the U.S. consulate abroad, that raises a presumption of preconceived intent. So what you may start to see is a change in the advice that you receive from your legal counselors with regard to potentially waiting until after 90 days before doing things such as changing your status as a visitor to a student, or filing, let's say, a marriage case when you've entered the United States. So these are some of the changes that we see. In the release that was put out by the government, what they say is that what will trigger the application of the rule are a couple of points. The first one is if the individual engages in unauthorized employment, that will raise a presumption of the preconceived intent if it happens before 90 days. If the individual enrolls in a full-time academic study without authorization, or the appropriate change of status, that will also raise the presumption. If the individual is a non-immigrant in status prohibiting immigrant intent, such as marrying a U.S. citizen, that also could raise the presumption. Or if the individual undertakes any other activity for which a change of status or adjustment would be required without changing or adjusting their status. So essentially, these various types of factors could be looked at or deemed by the government to be issues of preconceived intent, which raise the issue of potential misrepresentation. So if you'd like additional information on the new guidelines, again, shifting that 30-60 day rule, which was previously in the Foreign Affairs Manual, now out to the 90 days, please feel free to reach out for us at the NPZ Law Group. Our immigration lawyers are more than happy to provide you with information and documentation that can assist you. If you, your family members, or any members of your staff have any additional questions, please feel free to reach out for us at the email address or the website address below, or you can call our office at 201-670-0006. Thanks very much for being with us today.